Good day, Crime Talk aficionados. As you can see, we are back in the Crime Talk studio. We have a great show for you. First, the mystery hearing in the Bryan Kohberger matter. What could it possibly be? Today is the date to start the trial for Sean P. Diddy Do-It Combs. A Karen Reed trial update. An attorney has been arrested for killing his client 10 years ago. And wait until you hear the alleged reason why he did it. Donna Adelson gets what she wants, doesn't she always? This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications, and you can check us out on any of your favorite podcasting apps. Now, before we get to the docket, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do a background search on anyone here in the United States. It only takes a couple of minutes. The report is emailed to you, and it's going to have all types of information that you want to know about somebody. For example, it's going to give you their phone numbers, their emails, their social media presence, whether they have a criminal history, do they have liens, do they have judgments, do they have to register on one of those registries that you hear so much about. Everything you want to know about somebody coming into your life, ladies and gentlemen, that maybe they're not going to tell you why or what is going on in their life. So go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for Monday, May 5th, 2025. Yes, that's right. The secret hearing in the Bryan Kohberger matter. That hearing was held today. It was set for 11:30 today. They're in Idaho. Obviously, it's in regards to the case of Bryan Kohberger, and it's just days after the University of Idaho murder suspect lost basically every motion that he filed to avoid the death penalty. Now here we are, just 3 months before Kohberger's trial is set to begin, and the Judge Stephen Hippler, has scheduled a closed-door remote hearing today. Now, the details of the hearing are closely guarded secret, with both the media and the public blocked from attending. And as what we can tell so far, no leaks about what was discussed. Now, Judge Hippler has gone to great effort to make details about this trial open to the public. So it is a little surprising that he had this secret hearing. Now, since the trial has been moved to Boise from Moscow, Idaho, there in Latah County, where the murders took place, the judge has allowed cameras inside the courtroom, and he has live streamed all of the proceedings. And the judge also ordered both prosecution and the defense to stop filing records under seal. This one, the reason for filing it, is under seal, and so is the hearing. Anyway, some court documents have revealed many before never known details about the events of the night that Bryan Kohberger is alleged to have committed a quadruple homicide. And it's obviously the hearing, it could be under seal because it involves information about the victims, witness testimony that the court doesn't want to be made public as of yet, evidence that may or may not have been admitted at trial, jury issues, or Kohberger's own mental health or potential competency issues. Maybe there's a potential plea deal on the table. Who knows? It could be anything. So like I said, it could be something procedural, or it could be something very important, or it could be really nothing at all. Generally, hearings and documents are not sealed in criminal court cases, except in Idaho, as we've discussed several times on this channel. And it is frustrating that this requires, at least the judge thought it required to be held in secrecy. Hopefully, the judge will issue orders on it, and we'll get to find out what it is about. Normally, there is a presumption that these things need to be held in public. Like I said, Judge Hippler has pushed for these unsealing since taking over the case, and so it was a little surprising that he did this. Something being done in private and sealed should be the exception rather than the rule. The judge has stated himself in orders, and he's even stated that he wants great transparency and access, and he would lift the very broad gag order in the case. Now, due to this case being not typical when it comes to public access, it is difficult to determine how critical the sealing may have been. And had it been something like the Lori Vallow case or the Chad Daybell case, where everything was done in secrecy, that was very troubling to me. very disturbing. How do we know what took place? How do we know if the prosecution, the judge, and the defense were being treated fairly? We don't. I think it's a travesty of justice when things like this are sealed. Anyway, like I said, this Judge Hippler issued this mystery notice of the sealing hearing on April 30th, just one day after the judge handed down the latest court orders. And all those orders was kind of a blow for the defense in the Kohberger case. And the judge dismissed Kohberger's efforts to stop a jury from sending him to death row. And despite the timing of this hearing coming after the orders, we can't really say that maybe, like I said, is Kohberger going to change his mind for a plea deal? Is there going to be something that's been resolved? I don't necessarily think that will be the case, but you never know. We saw that in the Chris Watts case. I remember when they set it for a hearing, I said, well, they're either going to reschedule this hearing for the preliminary hearing or they've reached a deal. And sure enough, they did. And those are sometimes things that take place. And if there is going to be a plea deal, I'm assuming that the parties would discuss with the judge whether they thought this is appropriate, whether the judge would allow it. But that's going to require lots of moving parts on the other side. But remember, this is a death penalty case. Death penalty's attorneys think they win if they take death off the table. Even better yet, if they can get life. But normally the prosecutor wants acceptance of responsibility. And then we hear from the defendant's own evaluators, psychologists and what have you, that evaluate him, saying that he thinks he's going to be acquitted. So usually they want complete acceptance of responsibility on the record before some sort of plea is accepted in a death penalty case. Anyway, so could there be a deal? Could there be not? Yeah, it's possible. I just don't necessarily think that's going to happen from what we've heard thus far. But, what can you do? This is obviously a very serious case, one of the most gruesome murders, not only in the United States, but certainly Idaho. You got 4 college students brutally stabbed to death for no apparent reason. A lot of prosecutors wouldn't necessarily cut a life without the possibility of parole deal unless they thought that there was some weakness in their case. And there'd probably be a huge uproar against making any kind of a deal as well. But like I said, we won't know unless the court issues an order stating what the secret hearing was about. Now, like we brought you last week and the week before last, we brought you all the court orders. But for those who have joined us for the first time, the court dismissed Kohberger's efforts to strike the death penalty over what it claimed was the prosecution's lengthy delays in handing over voluminous and unorganized discovery in the case. The defense claimed that it was unable to prepare properly for trial, arguing that this was a violation of Mr. Kohberger's rights and asking the judge to strike the death penalty. Judge Hippler tossed those requests and blasted Kohberger's attorneys, basically saying that their complaints against the prosecution ring hollow. The judge said specifically, defendant complains of being unable to meaningfully review the discovery. That rings hollow. Defendant has been receiving discovery in the same manner for the last 2 years. No complaints. Dismissing the idea that there had been any misconduct by the prosecutors, the judge pointed out that Kohberger had asked for everything, and everything is what he received. And he said that the defendant cannot demand everything under the sun and then complain about the weight of all the planets. He scolded the defense. Anyway, the ruling came 1 week after the judge denied a separate request to strike the death penalty due to his recent autism diagnosis. The defense had come up with an expert who just recently diagnosed Mr. Kohberger with autism spectrum disorder level 1. And the significance of that is they're trying to look for some sort of disability, because if you're disabled, mentally impaired, then the United States Supreme Court says you cannot be subject to the death penalty. Anyway, the defense argued that the demeanor of Mr. Kohberger, because of his diagnosis, would place him at greater risk for being sentenced to death, and arguing that every move Mr. Kohberger makes is scrutinized, and claiming that he has been presented in the media as evil and soulless. The state, however, argued that the precedent previously set to strike the death penalty are for intellectual disabilities, and autism is not in that spectrum of intellectual disabilities. The judge ruled that Mr. Kohberger's diagnosis can be used as a mitigating factor if sentencing is at issue, but does not mean that the death penalty should be removed from the case. Now, Mr. Kohberger could face the firing squad if convicted and sentenced to death due to some recent changes in the Idaho state law. And also in another order, the judge also ruled that the jurors will be able to see Kohberger's Amazon shopping history. Prosecutors say his shopping history reveals that he bought the K-bar knife, sheath, and sharpener from Amazon back in March of 2022, and a K-bar leather sheath was left behind by the killer next to Madison Mogen's lifeless body. And then DNA found on the sheath back as a match to Mr. Kohberger, and the murder weapon itself has never been found. Now, the DNA, the defense all but conceded, was in fact Mr. Kohberger's. They made no claim that it wasn't his, but they provided no explanation how his DNA just happened to be on a K-bar, which he allegedly purchased from Amazon, which was his, and it just happened to be underneath the deceased body of Madison Mogen. We'll have to wait for trial for that, I guess. Anyway, Mr. Kohberger was arrested 6 weeks from the date of the slayings at his parents' home in Pennsylvania. As well as the DNA evidence and the eyewitness testimony, prosecutors say Mr. Kohberger's white Hyundai Elantra also matches the car seen leaving the crime scene at the time of the murders. And there's also cell phone records that indicate that he may have been kind of hanging around the King Road home at least a dozen times leading up to the murders. So hopefully we'll find out some information soon about the secret hearing. Could it be a plea deal? Could it be a scheduling issue? Could it be an issue related to Mr. Kohberger? Who knows? Maybe he wants to fire his attorneys. Maybe he wants to, raise competency. Who knows? But that's the problem when you do stuff in secret. Everybody starts to speculate as to what's taking place. Let us just have the facts. We're big boys and girls. We can handle it. Well, ladies and gentlemen, next on the docket, Sean Combs. That's right. Today is D-Day for Diddy. Now, old Sean P. Diddy Do It Combs is charged with racketeering conspiracy, 2 charges of sex trafficking, and 2 charges of transportation to engage in prostitution. Now, the federal indictment includes accusation that guns found in Diddy's house had defaced serial numbers, that kidnapping and arson were used to intimidate his victims, and that he also tried to bribe people and obstruct justice. You would think maybe one of those is going to stick. We'll see. Obviously, the jury selection is just beginning, and Sean Combs is entitled to the presumption of innocence, which we shall give him. And hey, just because you like to have random sex with lots and lots of people, that's not a crime. Unless, of course, you drug them, you force them, you ship them over state lines to prostitute them. Now, that would be illegal, but that's a question of fact for the jury to decide. So like I said, jury selection began this morning in a tough jurisdiction there in the Southern District of New York for the federal sex trafficking and racketeering trial of old Sean P. Diddy Combs. Now, Sean faces up to life in prison on racketeering and sex trafficking charges, with prosecutors alleging that he forced his ex-lover into so-called freak-offs and ran his company really as a criminal enterprise. Now, Mr. Combs has pled not guilty to the charges and turned down a plea deal from the prosecutors about 10 days ago, the details of which have not been made public. But there's been some rumors, and some sources have said that old Sean Diddy Combs turned it down because he is and his high-powered legal team believe that they can beat the case. That's always a precarious situation to do. And not saying he doesn't have very skilled counsel. He does, but let's be realistic. Most cases in federal court result in a plea, and most trials in federal court result in a conviction. Federal courts are usually much different than in state court. State court, they kind of react, right? Crime is committed, they charge somebody, then they kind of put the case together. The feds, it's a little more unique. The agents go to the U.S. attorneys and say, hey, we think we have a case. They kind of shop it around amongst the U.S. attorneys, and or there's assigned a U.S. attorney to their case and say, let's proceed with this case. And then the United States attorney says, okay, I think we've got enough evidence now. Shut down the investigation. Let's go get some indictments. Let's arrest people, and then let's go forward. So they build the case, and then they arrest you. It's not like in state court where you suddenly state police trip over the body and say, hey, we need to solve this. And the feds, they build the case, and when they think they have you dead to right, then they indict you. Now, like I said, the feds contend in their indictment that Combs abused, threatened, and coerced women and others around him to fulfill his sexual desires, protecting his reputation and concealing his conduct. Now, Combs' teams, however, maintains that he is just a swinger, and his sexual escapades were merely the consensual adventures of a high-flying tycoon. There's a lifestyle. Call it swingers or call it whatever you want, I guess. But he thought that it was appropriate because it was common, is what Combs' defense attorneys are saying and what they said in court at a hearing on April 25th. Now, obviously, Combs, let's be realistic, has an uphill battle anytime you're in federal court. It's an uphill battle. And the prosecution will be able to refer to the now famous video of old Sean Combs violently assaulting his ex, Cassie Ventura, in a hotel hallway. And there's already a lot of negative publicity out there about that particular video. It doesn't look good. Let's face it, it doesn't look good. He's not treating his girlfriend with respect. I would definitely say a crime had been committed. I don't think you can say that was consensual or that it was self-defense in no way possible. Anyway, like I said, trial's getting started. Combs has been in custody since he got arrested back in September, but yeah, you can see this is moving pretty quick, right? September, October, November, December, January, February, March, April, May. Here we are, right? 7-8 month time period. That's the way these cases need to go. I mean, Combs is looking to spend the, same amount of time in a lot of cases that go on and linger for years, ladies and gentlemen. The feds move fast. Now, how did all this get started? Well, the feds raided the producer's home in Los Angeles and Miami in May of 2024 as part of this sex trafficking probe against Mr. Combs. They found 1,000 bottles of baby oil and lube that were allegedly used during freak-off sex sessions, according to the indictment. Now, let's face it, ladies and gentlemen, having baby oil is not a crime in and of itself. It's not, but it certainly makes you wonder why somebody would buy 1,000 bottles of baby oil. Maybe they just use it to get their freak off. I don't know. We're going to find out here in the next coming weeks. Now, what's the defense strategy going to be? Well, we talked about it like last week, but we'll do it again. First, you got to get around the negativity of old Sean P. Diddy Combs. But the reality of it is, they're going to want to hear an explanation. You got to do the humanizing. You got to try to, show that this is not a criminal enterprise. It's just a bunch of, whether you like it or not, a bunch of entitled, rich people thinking that they can do whatever they want. And maybe they did, but it's not illegal. You've got to go consent. And with the minors, you have to deny. Nothing went on illegally. That's what the defense is going to be. You're also not going to argue to the juries, well, you may not like it, you may not be what you would do, but it's not illegal to engage in this, but it's not sex trafficking when you have willing participants. Now, the indictment also goes on to maintain that the sex extravaganzas required advanced planning and multiple organizers. And the indictment also explains how the case became federal because, well, it's alleged that Mr. Diddy brought people across state lines for transportation of minors for sexual work. You can't do that, ladies and gentlemen. You shouldn't even do it within state boundaries. Don't do it. Now, as per the indictment, the freak-offs were allegedly marathon sessions that occurred regularly, sometimes lasting multiple days and often involved multiple commercial sex workers. The indictment also alleges that drugs and video cameras were used in the proceedings to kind of get things going. And during the freak-offs, Mr. Combs distributed a variety of controlled substances to victims, in part to keep them obedient and compliant, according to the indictment. And then sometimes, unbeknownst to the victims, Combs kept videos, that's right, of the everybody engaging in various sexual acts with commercial sex workers. And then after the freak-offs, Combs and his victims typically received IV fluids to recover from the physical exertion and drug use. Now, I just happened to go to a wedding in Florida this weekend. Wasn't a problem for me. I felt great. I didn't drink, but let's just say I saw a lot of people that were hurting units, and they would have loved to have had an IV that following day, but there were just none around. What can you do, ladies and gentlemen? We're going to see it develop. We'll bring it to you. as the information comes in. Unfortunately, in the federal courts, they do not have streaming in the federal court system at all. Next on the docket, a Karen Reed update. Well, the trial of Karen Reed, the Massachusetts woman accused of murdering her boyfriend, John O'Keefe, entered its third week after heated testimony from one of the star witnesses for the prosecution wrapped up last Friday. Now, Jennifer McCabe, a friend who went out drinking with the couple the night before O'Keefe died, testified that the Karen Reed, the former finance professor, confessed to hitting Mr. O'Keefe with her Lexus. Now, prosecutors say that Reed then fled the scene, leaving O'Keefe for dead in the snow outside of a Canton, Massachusetts home of a fellow Boston police officer back in January of 2022. Now, the defense attorneys have maintained that Reed was framed. They say that text messages McCabe sent in the afternoon of O'Keefe's death show that she helped cover up how the police officer died and pressed her about records showing her phone made a browser search how long to die in the cold at 2:27 a.m. Well, we know that really isn't how that turned out now, is it now? Anyway, McCabe took the witness stand for 3 days, delivering testimony about Reed's admissions, vivid detail about discovering the body of one of her closest friends, and Reed's crazy and erratic behavior the morning after a night of drinking. But after McCabe's testimony ended, Hannah Knowles, a forensic scientist at the Massachusetts State Police Lab, told jurors Reed's blood alcohol level at 12:45 a.m., the morning that O'Keefe died, could have been anywhere between 0.14 and 0.28. The legal limit is 0.08. So we're talking anywhere from almost a little above twice to 3 times the legal limit. And I guess the defense there will be, well, she obviously had drinks after she got home because she wasn't driving. She wasn't drunk at the time, right? That's the defense. Anyway, Katie McLaughlin, a Canton firefighter who drove O'Keefe to the hospital in an ambulance, said she heard Reed say, "I hit him," at least 4 times at the scene. We know what the defense is going to say. Liar, liar, pants on fire. Anyway, McLaughlin said Reed made the remark as she was trying to gather information about O'Keefe's medical history. And McLaughlin told the prosecutor she didn't feel comfortable asking Reed any more questions given the disturbing scene and Reed's demeanor. She was upset, the Miss McLaughlin said, saying that she was practically hysterical. Anyway, defense attorney Alan Jackson pressed McLaughlin about why she didn't write Reed's statement down or follow up with her before reporting it to her fellow first responders. Jackson also questioned her relationship with members of the Albert family in a tense exchange, showing photographs of McLaughlin and Caitlin Albert and Bryan Albert's senior's daughter. McLaughlin said that she's known Caitlin Albert since high school and they have spent time together, but doesn't consider her a friend. Jackson asked McLaughlin if Albert's brother, a Canton police officer, was the one who set up her interview with the Massachusetts State Police. McLaughlin said that the interview was arranged by a state trooper. She said that she never spoke to Kevin Albert ever. Now, Sarah Levinson testified that she and a friend went to 34 Fairview Road to celebrate Bryan Albert Jr.'s birthday. Levinson said that the atmosphere was celebratory, light, joyful, and friends and family members came over and left throughout the evening. Around midnight, Albert's father, mother, sister, aunt, uncle, and friend, Brian Higgins, arrived at the house, and Albert's aunt, Jennifer McCabe, is one of the prosecution's key witnesses. She is the sister of Nicole Albert, who is married to Bryan Albert Sr., one of the men Reed's defense has alleged killed O'Keefe. Now, McCabe testified that Reed and O'Keefe were supposed to join the party at Albert's house, but never arrived. Levinson said her friend left the house briefly to speak with her brother. No one else entered the house after that. Levinson said that she left 34 Fairview between 1:30 and 2 in the morning with the McCabes, and there was a light dusting of snow on the ground. Now, the defense attorney for Reed began questioning Levinson by asking why she never met the Albert's German Shepherd, Chloe. Is that because the dog was not really good with strangers? Allen asked. Chief among the evidence in Reed's defense was a series of marks on O'Keefe's arm and appeared to come from an animal attack, as the defense alleges. And David Yannetti, Reed's lawyer, argued at the trial in 2024 that the dog did it. Anyway, two witnesses told jurors they spotted a black SUV while on their way to pick up a friend from the home where O'Keefe was later found unconscious in the snow. Heather Maxson said she saw a woman driving with a man in a front passenger seat of an SUV as both cars turned into Fairview Road. Maxson said she did not recognize either person. Ryan Nagel, Maxson's then boyfriend, estimated that they arrived at 34 Fairview Road just before 12:30 and saw the SUV parked nearby. Nagel said he saw a woman in the driver's seat of the SUV, illuminated by the interior dome, but his glimpse was too brief to be able to identify who it may have been. So Nagin and Maxwell both said they never saw anyone exiting the SUV, lying on the lawn, or entering the home while they were parked outside of the Nagel's sister's residence. After a brief conversation, Nagel's sister ultimately decided to stay at the house, and the group left the scene. Let's talk about Karen Reed's blood. Now, Ms. Knowles returned to the stand on May 5th to briefly wrap up her testimony. Knowles previously told jurors that Reed's blood alcohol level was between 0.078 and 0.092 when she tested at the hospital after 9 a.m. on January 29th of 2022. And based upon retrograde analysis, she found Reed's blood alcohol level at 12:45. The morning could have been as high as 0.14 and 0.280, far beyond the legal limits for driving a motor vehicle in Massachusetts or anywhere in the United States. The findings were based on blood samples taken from Reed at the Good Samaritan Medical Center in Brockton, Massachusetts. Now, Ms. Reed's attorneys attempted to gain a little reasonable doubt about the accuracy of those calculations, questioning Knowles about the many factors that affect a person's blood alcohol level and calling her results imprecise. Knowles explained to prosecutors the blood level range that she produced was intentionally wide to account for many factors that the defense raised. Before her second trial even began, Reed told Vanity Fair she owed her attorneys more than $5 million in fees, ladies and gentlemen. So I guess all the Karen Reed supporters need to start those donations going now. Ms. Reed also told the magazine that she's living off what was left of her 401k retirement fund after losing her job at Fidelity Investments as an equities analyst, as well as at Bentley University as a finance professor after being arrested for the charges. She stated in one of these interviews, "If I can't get the entire truth out of this case, out of the public forum, that for her is priceless." Anyway, the Justice for Karen Reed Legal Defense Fund, organized by Workman, Jackson, and Quinn, has raised more than $900,000 from more than 11,000 donations. Donations have continued to flow in during the second trial. Reed supporters from across Massachusetts and beyond have sold T-shirts and held events, including a recent cocktail-style party to raise funds for her defense. Now, I think that's a little bit in bad taste. When you're accused of hitting somebody while you're drunk, don't have cocktail parties, but that's just me. Anyway, Reed also sold her 4-bedroom, 3-bedroom home in Mansfield for $810,000. That deal closed in November of 2024. There you go. Most recent update on the Karen Reed trial, ladies and gentlemen. They I believe, have just broken for the afternoon. Next on the docket, a divorce attorney charged with killing his client in a cold case. And wait till you hear why. So 12 years after the Cleveland Clinic nurse Eliza Sherman was brutally stabbed to death in broad daylight, the attorney representing her in her divorce case has been indicted for her death. Now, according to the Cuyahoga County Prosecutor's Office, Gregory Moore is charged with 1 count of aggravated murder, 1 count of conspiracy, 6 counts of murder, and 2 counts of kidnapping. Now, Sherman was at the time a 53-year-old mother of 4. She was killed in the middle of the day in downtown Cleveland on March 24th, 2013, near Mr. Moore's office. Now, according to the indictment, which was made public after Moore's arrest, he allegedly lured Sherman to where he worked, saying that he needed to meet with her. The indictment alleged it was part of a plan that was hatched months earlier to kidnap her to avoid having her try her divorce case in court. As Sherman waited for someone to unlock the door at Moore's office building, an individual who was either Moore or an unknown co-conspirator, approached Sherman, circled behind her, chased her, and then stabbed her more than 10 times, according to the indictment. Now, Moore was also allegedly disconnected his phone from the cell network for 3 hours around the time of Sherman's death in an attempt to avoid creating cell phone tower location evidence. He must have been watching Crime Talk. Just kidding. We weren't doing this when this all went down. Anyway, according to the indictment, he turned his phone back on, made several calls to Sherman's phone to cover his tracks. He then got a new phone a few days after her death. Now, Moore was not a stranger to authorities, according to police reports. In 2017, he pled guilty to falsification of statements he made to police about his whereabouts during Sherman's killing. He also admitted to calling in bomb threats in 2012 as a way of delaying trials. His law license was suspended in 2017, and he ultimately turned his license in the following year. He also served 6 months in jail. Well, the U.S. Marshals arrested Mr. Moore Friday at a relative's house outside of Austin, Texas, where he was taken into custody without incident. Now, in Northeast Ohio, the Ohio Bureau of Criminal Investigation Crime Scene Unit descended on Moore's home in Sagamore Hills, and they executed a search warrant at that residence. Now, Mr. Moore is expected to be brought back to the Cuyahoga County to face a judge sometime this week and have a bond set. Interesting. Never, ever crossed my mind to kill a client so I wouldn't have to go do a trial. I mean, was the guy just so unprepared? I mean, what was he thinking? I can't wait for this one to unfold. Very interesting. Why not just go try the case? It's a divorce case. What's it going to take? A couple of hours, couple of days at most? My God, unbelievable. All right. Next on the docket, Donna Adelson gets what she wants. A judge has granted a request from Donna Adelson's defense team to delay her upcoming trial. Well, Miss Adelson, she's getting up there. She's 74 years old, and she's charged with first-degree murder, conspiracy, and solicitation in the 2014 death of her ex-son-in-law, Dan Markle. She's pled not guilty. Now, Adelson, who appeared at the hearing last week via Zoom, was scheduled to go on trial beginning June 3rd. The defense sought the continuance because they said they needed more time to review the new discovery in the case, because that evidence came through wiretaps of over 80,000 emails. They also told the judge that they were waiting on discovery they're entitled to under the rules governing jailhouse informants that have not yet been received. So it means that Miss Adelson's maybe talking to somebody in the jail. Swell. What do I say, ladies and gentlemen? Who always gets them with their own words? The defendant. Anyway, this includes whether anyone has been given favorable treatment in exchange for testimony, as well as statements that the prosecution wishes to elicit at trial. On Friday, Judge Everett issued an order delaying the trial without setting a new date. The motion notes that no further continuance shall be granted without good cause presented, which is the judge's way of saying, I'll give you one continuance, but that's it. Now, for those who do not recall, Mr. Markle was an FSU law professor, and he was gunned down in his garage in what was eventually revealed to have been a murder for hire plot. Adelson's son, Charlie Adelson, was convicted of hiring 2 hitmen to carry out the killing. Charlie is currently serving a life sentence without the possibility of parole, and is one of the hitmen in the case. The other hitman took a plea deal, and an ex-girlfriend of Charlie's served as the liaison between the Adelsons, and the hitman is also serving life without the possibility of parole. Donna was arrested 1 week after Charlie's November 2023 conviction, boarding a plane to Thailand with somewhat restrictive international extradition treaties. Anyway, the judge also announced at the hearing that May 16th will be the filing deadline for any motions. He also stated that prosecutors have until Friday of this week to hand over all discovery related to the informants to the defense. Earlier this month, a defense motion to remove the judge from the case was denied. A previous defense request for a change in venue is still being considered. All 3 of this month's defense motions were filed under seal, so details have not yet been released to the public. I hate that. I never get to do that. I mean, the only time you get to file something under seal is maybe a plea agreement for an informant, for safety reasons, but that's it. I mean, what is this? I don't get it. Secrecy in criminal proceedings, big no-no. Next, this day in legal history, May 5th, 1865, the 13th Amendment debate advances, aiming to abolish slavery. Obviously, a transformative legal step post-Civil War. On this date of May 5th, 1905, the United States Supreme Court rules in Lochner v. New York, striking down labor regulations, a key case in the economic liberty law area. And on May 5th, 1925, high school science teacher John Scopes was arrested for teaching evolution in the Tennessee public schools, right? The infamous Scopes monkey trial. And on this date in 1950, the Uniform Code of Military Justice was proposed, and later the military law and court-martial procedures were standardized. On this date in 1969, the Tinker v. Des Moines ruling impact spreads, with schools revising policies to protect students' free speech rights. That's right. Kids have some free speech rights in school, even though when you go to school, they take the place of the parents and they should be able to discipline you as you deem fit. But you can't take away the First Amendment rights. And then finally today, our dumb criminal of the day. Please meet Vincent Conroy. He was allegedly drunk and walking around a Florida parking lot wearing only a t-shirt. That's right. Only a t-shirt, ladies and gentlemen, with no pants. This all took place early in the morning. And when the police arrived, his private parts were apparently on public display. Mr. Conroy was spotted with 2 wine bottles and a can of beer. When confronted by police, this is where it gets interesting, he identified himself as Charles Dickens. According to the arrest report, it was later discovered that his name was Vincent Conroy, not Charles Dickens, the author. In addition to an open container and exposure of his sexual organs counts, Mr. Conroy was charged with providing a false name to law enforcement. Mr. Dickens. Anyway, after a day of being in the local jail, he was freed on his own recognizance by the judge, obviously ordered not to commit any new law violations. And so, therefore, here you go, Mr. Vincent Conroy or Charles Dickens, whoever you may be, you are our dumb criminal of the day. Congratulations. You made it. All right, that's all we have for today, ladies and gentlemen. Hope you enjoyed the show. We'll see you next time on Crime Talk. And remember, the Constitution matters.